Over the years, the United States has set up great trading relationships through formal treaties of friendship and commerce with more than 30 countries in the world. If you are a business owner who is a citizen of one of these countries, and you currently do trade in goods or business with the United States, then you may want to consider the E-1 visa for treaty traders. Like the so-called sister visa for E-2 treaty investors, the E-1 allows a trader to open up and operate a business entity in the United States. It facilitates trade between the U.S. and your home country. It allows you to relocate to the States to better manage the flow of trade. Unlike the E-2 for investors, however, there's no requirement to create jobs. Instead, the trader must demonstrate that substantial trade exists between the U.S. and the trader's home country. So let's tackle a few of the key requirements for an E-1 visa. To start off, it must be proven that your business abroad is currently doing trade with the U.S. What is trade? Well, E-1 regulations require 3 key elements. First, there must be an actual exchange of goods or services between the U.S. and the foreign treaty country. The flow of goods and services must also be international in scope. In other words, a foreign company cannot set up shop in the U.S. and serve only American clients. Instead, the flow of business must reach back to the foreign company's country. And finally, the trade must involve qualifying activities, which could be in the form of physical movement of actual goods, or transportation, or non-physical services, including consulting, international banking and insurance, tourism, and technology. In addition to this, we must prove that the trade is also substantial. What exactly does substantial mean? Well, there's no one-size-fits-all definition to this. Instead, the adjudicating officer of the E-1 visa application will look at your overall business model and ask, is there a continuous flow of goods or services between the two countries that generally involves numerous transactions over time? The officer will also consider the monetary value of each transaction. While there is no minimum requirement set in the regulations for this, the officer considers whether the volume and value of trade will generate more than net profit to support the treaty trader who will be living in the United States to manage the flow of international business. Finally, E-1 regulations require that at least 50% of your company's total international trade is with the U.S. If your company has trade with other countries besides the United States, the application will fail unless you can show that 50% of all international trade is with the States. The E-1 is a great category for global businesses doing trade with the United States. It allows managers, executives, or essential employees with the business to transfer into the U.S. Depending on visa reciprocity agreements, E-1 visas can be granted for up to 5 years, and it may be renewed so long as the applicant maintains non-immigrant intent. I'm Jennifer Behm, a partner with Berardi Immigration Law. If you are a business executive who is interested in learning more about the E-1 category, call our firm today. We'd love to work with you on your E-1 visa application.